watchdog has gone to court saying you guys are not doing your duty in providing these documents.
Well, if that is indeed the case, I have to say I think it's a waste of scarce resources when she could have just as easily entered into the same kind of agreement that any other independent officer would enter into in order to view cabinet materials.
So I've read through the back and forth between your ministry and she doesn't agree with you. It seems like this is the only way to resolve it.
Well, there is another way to resolve that, and that is to enter into the very same agreement that any other independent officer would enter into. It's important to note that in spite of the perception that she utilizes cabinet documents on a regular and ongoing basis, that's just not the case. Since 2006, she has only ever made one request to MCFD for cabinet-related materials, and in fact, since 2006, she has not once, that I'm aware of, utilized cabinet documents in the preparation of any of her reports.
So why did you need to do this legislation to stop her from accessing documents on an audit she's been working on for 2 years?
This amendment does not stop her from accessing cabinet documents. What it does do is ensure that we are explicit about where the discretion lies with respect to releasing that information. As we stated in the letter that we sent to her outlining our proposal for the amendment, she still has the option of entering into an agreement that any other independent officer would enter into. This will in no way affect her access to cabinet information.
So she is not in possession of any cabinet documents whatsoever?
No, she made one previous request for cabinet information that was provided to her. It was based on a historical initiative that was no longer relevant. But that cabinet material has not been utilized in any published reports. Insofar as her published reports to date, I am not aware of any cabinet material that has been utilized in the preparation of any of those reports.
So she only has cabinet material in response to one request. That's the only cabinet material she has in her possession at the present moment in time?
That's the only cabinet material that I am aware of that she has been provided since she was first appointed in 2006.
Where does this leave you in terms of a relationship with the independent watchdog? This is supposed to be oversight on your ministry. You seem to have come to a fundamental disagreement with the person that's doing that oversight.
Well, again, it's unfortunate that there has been a dispute and a disagreement about this legislation, but nevertheless, we continue to offer solutions that would not involve going to court, would not involve wasting those resources, and would, again, allow the representative access to the cabinet documents that she seeks along the same lines as any other independent officer. So again, this amendment in no way impedes her ability to do her job. She still will retain broader powers of access than almost any other independent officer, full and complete access to all MCFD-related documents and those that are confidential case files, full and complete access to coroner's information. And again, this is not a situation in which she has regularly utilized cabinet information in her work.
So what is this about?
It's a fundamental disagreement as to what she believes she's entitled to, and we have an obligation by law to protect the confidentiality of cabinet materials. As such, we enter into protocols when we release those documents to independent officers, and we are not asking the representative to do anything beyond that.
She says that a protocol would essentially be a government veto on her reports, that she would have to get government's permission and look through and look at what is disclosing and they can sever things from her report, and that it's not appropriate for an independent office to have to get reports vetted by government.
Well, that is the process that's utilized with the Office of the Auditor General. And certainly I think all of you would concur that the Auditor General has not been hampered in his ability to produce reports that are not necessarily favorable to government. So all I can say is that has not been the experience of independent officers with respect to the utilization of protocols in the past. There's no reason to think that it would be any different for her.
Just a couple of weeks ago on Voice of BC, you said that the relationship between your ministry and the representative wasn't dysfunctional. Would you revise that assessment at this point?
Well, again, this is a dispute about a legal matter. I understand that she feels that she needs to pursue that in court. We disagree. I continue to present to her, as does government, the opportunity to resolve this without going to court, and that is to enter into the same process as any other independent officer, recognizing that she retains broader powers of access to information than almost any other independent officer, full and complete access to MCFD, all our confidential case files, full and complete access to the coroner. So again, we're not asking that she do anything that would be any different from any other independent officer, and to make the point that in fact she's only ever made one request to MCFD for cabinet-related materials in the entire time that she has been in her office and has been producing many and varied published reports.
What precisely are you trying to hold back in this case?
Well, it really isn't about the particular information requested. It is about who has the discretion to release cabinet documents. And under statute, which we are guided by, it is not the representative who has the discretion to release those documents. She has wide discretion to release documents, even confidential ones, that she receives from the ministry or that she receives from the coroner's office. But with respect to cabinet-related materials, government has an obligation, any government has an obligation to protect that discretion. That should remain with the Secretary to Cabinet and not with the representative for children.
So why were the earlier documents turned over then?
That's actually a good question. In the first instance, again, that was a decision made by government, and it represents the kind of process that we see in place now with other independent officers, where we work with their office, we determine as government what pieces of information are appropriate for release, and in this case, it was a matter of a historical initiative that was no longer ongoing, and it wasn't felt that there was a difficulty with releasing the particular information. But that's why each individual request, when it comes to the Auditor General or other independent officers, is dealt with on its own merits, and a protocol is developed, because each circumstance will represent a different type of request and a different scope of information.
She seems to be suggesting she can't do her job without this kind of access, and she may not stick around if she doesn't get it. How concerned are you about that?
Well, there's absolutely no reason that this amendment would in any way affect her ability to do her job. She still has access to cabinet-related materials the same way that any other independent officer would. She still has full and complete access to all ministry documents, including the right to disclose those at her discretion. She still has full and complete access to coroner's documents and the ability to disclose those at her discretion. And again, if we consider the published reports that she has put out since her appointment in 2006, I am not aware of any cabinet material being utilized in the preparation of any of those reports.
Are you disappointed she's gone to court?
Again, I think it's a waste of scarce resources, and especially when there is a potential solution that is currently utilized by every other independent officer.